Ladies and gentlemen, this is being designed for myself, so I'm going to be doing work in the background. You're just going to have to follow along. On the 25th of March, the system wants to play games. They're claiming that they're going to have a trial. Now, I already know the games that they're playing. They already know that I know the games that they're playing, but they're going to go ahead and play anyway. We've already done the arbitration, and although they are afraid to talk about the arbitration, they're ignoring the arbitration. They are pretending it does not exist. Now, the reason why we know we can do the arbitration is this reason right here, so that you guys will understand, because it is real simple. The problem is most people won't get this. Even though I'm going to scream it and shout it to the top of my lungs, let's make sure you understand why you can do arbitration in a so-called criminal matter. Because they do it all the time. Arbitration is known as an alternative dispute resolution. Alternative dispute resolution is the same as a plea agreement. A plea agreement is an alternative dispute resolution. This is the problem with their system. This is why their system is a joke. See, if they want to have a program which they call an alternative dispute resolution, they don't get to narrow down what's an alternative dispute resolution and when it can and cannot be used. They don't have that option. They cannot restrict one from arbitration. The one thing the court said to me through its judicial officer was that I had to prove that such was permitted in a criminal matter. No, I don't. I ain't got to prove anything. You got to prove I can't do it. What you talking about making me prove? So I told him I won't participate. I told everybody your main weapon in anybody's court is your right to remain silent. Well, here is the problem. Most people keep talking. They don't protect themselves. Ladies and gentlemen, I told them I demand a jury trial. Well, of course, they have to give me a jury trial. There's only one problem. I won't be speaking. They're going to force an attorney on me. Guarantee you. I'm going to tell them, no, you don't have my permission to do that. I told you, because the so-called ignorant judge said that she was going to permit and allow certain things, and she was going to allow me to challenge certain things, and every step of the way she's blocked me. When I was talking, she interrupts me. I asked her, stop interrupting me. I said to her, you said you were going to allow me to say this, and you did not. I did. No, you did not. You interrupted me. Well, I interrupt everybody. Thank you for documenting that. Oh, by the way, you said that arbitration is not allowed. I just need you to say that on it for the record, that it's not allowed in a criminal matter. You said it is not allowed, so I need you to say it on it. I'm not going to say it on it for the record. Oh, okay. Okay. These are the games they're playing. So, let me tell you the genius. I was talking to my God on Saturday. I had made a choice to choose him and not rely on my own self. This is going to throw everybody off because everybody and their grandmama are going to be thinking the boy's crazy. What are you doing? Ladies and gentlemen, this is the most ingenious thing. I couldn't pick this out myself, but here's the point. I'm going to remain silent. When it comes to selecting a jury, I'm going to remain silent. Now, the one thing the judge is going to do is she's going to be stubborn. She's going to select the jury members for the so-called defendant. I represent the defendant. Nope. Objection. You don't have the right to do that. Again, until you permit due process, this can't proceed. See, it can't happen without due process. Due process says that I have the right to do this, the right to do that. They had 30, in California, they have 72 hours, 3 days to bring someone before a magistrate. They took 3.5 days. They decided that they were going to keep me in a cell with no clothes on, people. Just a little tarp that they put over me, as if I was going into a fire. No clothes on, no toilet, just a hole in the bottom of the floor. If I wanted to go in, that's what I could do. You understand? They put me on suicide watch. although there was no indication that anybody was deranged or out of their mind. For 6 days, no shower, no hygiene, no bed. Did this on purpose. They were trying to stress me out. So then I finally decided to give them the fingerprints. That's what it was about. Now, I didn't give them the fingerprints because I couldn't take anymore. It was just too much. Remember, I'd been in this situation before, so they weren't doing anything that I hadn't already experienced before. Now, I gave them the fingerprints because I had to prove that that's how they got their identification. But I had already reserved rights and told them that I would proceed under full immunity without recourse. They accepted my offer, even repeated the offer in court. I'm not concerned about that because the fingerprints photo, oh, you should see the way they doctored up the photo. They have me looking at some crazed and deranged person. But I'm not going to argue any of that stuff. Go right ahead. Make the photo darker, lighter, change the eyes, add this, add that. That literally, that's what they did. No problem. I'll be crazy. I'll be that. But here's the thing. Impanel a jury without the defendant accepting the jury. Go ahead. Let me see you do that. See, the process doesn't allow that. Ladies and gentlemen, I'm not talking. I'm not participating. I'm going to sit there and keep my mouth shut. Why? Because I have the right to remain silent throughout the entire proceeding. Oh, the biggest point is they have the request for subpoenas and they're not giving the subpoenas. You see that? Requested subpoenas and they're not giving me my subpoenas. Lordy be, Lordy be, Lordy be. This is interesting. Okay, ladies and gentlemen, I am going to conclude this. I just wanted to put on record what I was getting ready to do and how ingenious it was. They will do everything. They will even try to have a psychological evaluation, even though I have been found competent to represent the defendant. They did their little so-called Feretta hearing, and now they're going to try to claim that there's an issue. Really? Because I say I'm not going to talk, I must be stupid, must be insane, must be crazy. No problem. And then when the time comes, I will play this for the jury to let them know that the Fifth Amendment to the United States Constitution says no one may be held to answer for any crime without due process of law. Have the right to subpoena people. They know I'm going to subpoena their financial records, proving that they conduct commercial transactions all the time. They know I'm going to bring up the issue of arbitration. The wonderful little officer doing his investigation said that there are no policies and procedures for how they conduct an investigation. They conduct an investigation however they want to, which means they can do whatever they want. They can investigate whatever they want. There's no restrictions on them, but they received a subpoena to get records from Google. Excuse me, why are you pulling records from Google? This alleged crime, sorry, gotta say that word, that commercial crime thing, this alleged crime had nothing to do with Google. Nobody's accused of doing anything on the internet, so why are you searching Google? You can only search the things and matters. Well, they say I left an email address. Well, fine. I left an email address. I communicated a letter via email. Doesn't give you the right to search all of my emails. If I send you a letter in the mail, doesn't give you the right to ask for a subpoena asking for all of my mail. See, that's the whole thing. A warrant shall not issue unless upon probable cause. So how in the world could they get a warrant for probable cause when there was no issue dealing with the internet? Because this is what they do. Oh, and the so-called prosecution sat up there and handed me over 1,000 pages worth of junk. That's going to be the evidence that they're going to be introducing. 1,000 pages, all it is a bunch of pages from stuff collected over the last 25 years. Does this thing have anything to do with the last 25 years? Of course not. But this is what they do. They make it look like they have overwhelming evidence. 1,000 pages. Amazing, ain't it? And so what I'm supposed to do is I'm supposed to argue and focus on that 1,000 pages. I don't care about that stupid 1,000 pages. None of that is evidence. None of that is evidence of any crime, whether it be statutory and or commercial, which is statutory. But none of that is evidence of a crime, but they are going to say it is without providing any proof. Remember, you don't have the right to an appeal in this country. Why? Because it's an administrative court. You have a right to a review. See, the appeals court just reviews the record. You don't get to do an appeal. There is an appeals court on a federal level, and it is an appeals court. Give me 1 second. Let me show that to you. I'm looking for something, but I didn't find what I was looking for, so it's looking for nub in all the wrong places. Oh God, why did I do that? I could have used that page. All right, let's go. Yeah, we can go here, mediation. Then I can bring this to a close. Hey, I said mediation. What's wrong with you? All right. So let's do this. Oh, I was doing the research on the fact that arbitration can be heard in criminal matters. As a matter of fact, not only has arbitration been an issue concerning criminal matters, but this is the thing that speaks about mediation and how plea agreements are mediation. Let's see. Let's see. Introduction, introduction, introduction. See? They do alternative dispute resolutions in so-called criminal misdemeanor cases. Ladies and gentlemen, the fact is, it's done in a criminal case. The fact is, the court says that I needed to prove that it could be done in criminal matters. This is done all over the world. This is British Columbia, then you have it in Britain. Then there's another one that I just downloaded from China, the People's Republic of China. But she brought up a presumption. Sorry. The law of presumption means that in order to rebut a presumption, one must do so with a preponderance of evidence to the contrary. Well, I put in a motion for compilation of, not compilation, but compilation, compelling arbitration. My presumption supersedes her presumption because I raised the issue first. A presumption must be overcome by a preponderance of evidence to the contrary. They provided no evidence to the contrary, so the law requires that I stick to my guns with the arbitration. Give me 1 second as I put in. Now I forgot where I was going. And I said I was going to show this to you, and now I got to remember. Give me 1 second. Nope, I could not remember where I was going, but this is the Constitution. This is the fact. No person shall be held to answer for an otherwise infamous crime unless on presentment of indictment, a grand jury, except in cases arising, don't care about the militia, when in active service, don't care about that. Now, no person shall be held to answer for an infamous crime unless on presentment, and no person shall be subjected to the same offense twice or put in jeopardy of life. And the other part that we're looking for, let's continue to read because it is necessary. Well, this is the second part right here, but we might as well get the whole thing. This is the Fifth Amendment. No person shall be held. This is the first point that you need to understand, because the rest of this is not applying to what we're referring to. Pay attention. Nor shall any person be the subject. So it says no person shall be held, nor shall any person. So it means it's a continuation of that same sentence. It's a statutory interpretation. They're said to be only 9 principles of statutory interpretation, but there can be at least 19 or even more. But there are 9 basic principles of statutory interpretation. Nor shall any person be subject to the same offense twice or be put in jeopardy of life and limb, nor be compelled to, in a criminal case, to be a witness against him or herself. Well, anything you say can and will be used against you. Okay, that's why it's called a Fifth Amendment right. They can't force you to be a witness against yourself, but when you're in court, do they not tell you anything you say can and will be used against you? Which is why I accepted their offer with full immunity and without recourse. Nor be deprived of life, liberty, their freedom, or their property, their estate, that defendant character, without due process of law. Okay, nor private property taken for public use. without proper compensation. Well, when they take the defendant and they put the property in jail and they trade it on the market, they're putting that property in there and trading it for public use and not compensating the defendant representative. Remember, it is an estate. That's easy to prove. We just did that on video showing everybody about the constructive trust that the court creates for the minor, the infant. Now let's get back to the individual being compelled in any criminal case to be a witness against himself. Anything you say can and will be used against you because it's an agreement. You're agreeing to waive this right. Well, ladies and gentlemen, if I don't have the right to talk, that's a violation of the First Amendment. So that's why I conditionally accept your offer with full immunity. Did that before. That's the whole purpose of not giving them the fingerprints, because when they took the fingerprints, put in case law on the record where to give up the fingerprints would be a testimony against oneself. Well, they forced me through coercion. They withheld the food because I don't eat meat. And they kept trying to serve me meat day in and day out, purposely. No access to Bible, nothing. Denying me phone call access, purposely putting me in cells where the phone calls. So I told them, I said, hey, let's get this information. Let's pull up those records. Let's pull up the video cameras, because every cell they put me in had a video camera, because they were claiming that somebody was a sovereign citizen. So when I was questioning their number one witness about this sovereign citizen thing, objection! Excuse me. But that was the whole purpose of your investigation. That's what he was trying to find. He even puts that in his report, that he was looking for such information. They had 9 officers waiting for me when I got to the facility. Told me I needed to wait in the car while they got prepared and ready. So when I'm trying to get subpoenas to subpoena these officers, they want to deny me the right to a speedy trial, because I haven't waived anything. Where are my subpoenas? I told the court, the clerk of the court is not issuing subpoenas. Well, who do you want subpoenas for? It's none of your business. I don't need to tell you who I want subpoenas for. I have the right to subpoenas. Are you telling me I don't have this right? Of course they're not going to tell me that. But I still haven't gotten the subpoenas. I've been trying to get subpoenas from these idiots since December. And yes, I call them idiots because they want to play this game. They want to make it all look different to the public. So I'm going to keep silent. Why? Because the law says I have the right to remain silent. This is this section right here. Well, guess what? The 6th Amendment says that the accused shall have the right to a speedy public trial before an impartial jury. Well, I haven't waived my right to a jury. It's just, I said I want my due process. Do you see? I have the right to due process. What is due process? That they follow procedure, that they follow the law. That's due process. That's the process, that they must follow the law, but they're not following the law. They're following procedure. What do you mean they're not following the law? They're following procedure. Yes, they have an internal policy, internal procedure that they follow, that the public doesn't get to know about. And so I'm telling them no. Ladies and gentlemen, I gotta go. Hold on one second. You see, I want my due process. It's mine. It doesn't belong to them. No. It's my due process. It's my due process right. It belongs to me. See, the right to not speak is my right. They don't get to control that right. I control it. I get to choose when I'm not going to speak. So when they are impaneling their jury, I put in 30 questions for the jury. 30 specific questions regarding the law, because the jury is required to know the law. Okay, well, if the jury doesn't know these laws, especially this due process right, and how no one may be held, tried, and or convicted without due process of law, then they can't sit as a jury. Of course, you know they're not going to let those questions be asked. Oh, you guys didn't know? You get to put your questions to the jury. So I kept all of my questions specific with the law. Commercial laws, commercial crimes, the fact that a judge, when enforcing a statute, is not enforcing any law, but is enforcing policies of an administration, an agency. I don't explain all of this. I just ask the question, is this not true? I do the same thing with those questions as we do with the proof of claims in our contracts. And I do the same thing with the jury. I don't say proof of claim. I just ask, is this not the case? And I put the case law there. And of course, I promise you, they're looking for ways to block it, but they can't. Why? Because the questions being asked to the jury are common basic principles and facts and conclusions of law reached by courts. The people who put together the laws you never knew exist, they knew what they were doing. It's just nobody had ever applied it to jury questions. So now we're going to ask the jury questions before they get impaneled. If the questions are not answered, they cannot sit as a jury. That means you're being denied your right to a jury trial. Not their jury trial. Well, it's not a jury trial, it's a trial by jury. It doesn't matter, people. Whether it's a jury trial or a trial by jury, you still have the right to a competent jury. Doesn't matter how you phrase it. I'm not doing their phrases, I'm doing mine. When I speak, I'm not there to speak legalese. I'm not there to be construed. I've already told them my words cannot be construed but must be taken contextually. I'm not playing games with them. I'm not going to play the word game. Ladies and gentlemen, I'm not going to play their game. Now, their job is going to be to intimidate and to threaten. And I promise you they're going to threaten. What is the first thing they're going to threaten me with? They're going to threaten to lock me away. They're going to threaten to impose this and impose that. They're going to, oh, well, we just discovered this, and so we're going to ask that he be taken into custody. Sorry. You didn't just discover this. You've already had this information. What you're doing now is retaliation. But this is what you do. It's not going to change anything. So whether it be here or whether it be there or whether it be anywhere else, people understand that we're going to play this game and we're going to play it to the full, and I'm going to hold each one of you responsible personally in your individual capacity for violating the terms of the agreement. Because here is the agreement, and I carry the agreement with me, people. I carry the agreement, and I'll be carrying the arbitration award with me because I will have the arbitration award with me. I ain't got time for this stupidity. And by the way, ladies and gentlemen, the fact is, what do you do after you get the arbitration award? We'll be doing some videos over that over the next couple of weeks. And I'll be doing a video later today telling you all about the Angela Stark video. As you see, no, you can't see the date. Let's see, let's do it this way. Well, yeah, let's do it this way. Let you know what day today is. This is March 11, 2019. So this is just me documenting in advance what they're going to do before they do it, because this is what I do. They're going to threaten my freedom. I'm okay with them threatening my freedom. Am I in Los Angeles, California? Let me see, am I in Los Angeles, California? Hold on. Hold on. This thing says Los Angeles, California. Ladies and gentlemen, I know for a fact that I'm not in Los Angeles, California. But it says I'm in Los Angeles, California. Let me see. Let's do this. WHATMY. This is what Google does. I'm not in Los Angeles, but this is my IP address is this right here. Okay. Let's see. Let's go and see where I'm located with that IP address. That's not my IP address. Okay. Whew. I just Nepal. Okay, so how could Google say I'm in Los Angeles? Because Google does the search history, and when I first started using Google was back in 2016. I let it record the IP address in 2016, and I put a zip code for Los Angeles. Okay, and so when I get online, it does that. But as you see, I'm in Nepal. So not possible for me to be in wherever they're saying I am. So when the intelligent creatures are sitting up here trying to lock somebody in and trying to say somebody did this and did that, they're not realizing what the law actually allows and does not allow. Oh well. Ladies and gentlemen, gentlemen and ladies, this is only for documentation purposes. I have a lot of documents I have to finish up today, so I'm going to discontinue this video. Have a good day. Have a good day. Have a good day.